And I understand. I know if I think of a jury trial, that would be 25 plus years if I were to lose. That I understand. Um, I feel as if I don't have to go to that route, thinking I know I'm not gonna beat the case, but I feel my constitutional rights were violated.
It was at this moment that he knew. He fucked up.
This is the moment every defense attorney dreads. The defendant starts talking constitutional rights, but you can almost hear the record scratch. When judges hear this without a formal motion on file, it usually means trouble is coming fast.
The defense attorney and prosecutor. With regards to drug cases, sometimes people complain because there was a search warrant. They say the search warrant was improper, right? So that's something maybe you can file a motion on. Sometimes you have people who maybe were driving a vehicle pulled over by the police, and you say the police never should have pulled me over. And I'm just speaking to you in layman's term. And that may be a reason, right? So those are usually the reasons for people are saying, my rights were violated. Now, drug cases normally, and yours normally.
Here's the reality check. Judge Boyd calmly explains how drug cases actually work, especially habitual offender laws. This is not TV law. Prior convictions change everything, including how much mercy is even legally possible.
Usually, you know what it ends up being? They have somebody send what's called a PIN packet. And the PIN packet is a packet that has documents in it that will show that you were sent to prison or something before this case, right? So if that has happened twice before this case and the state is able to prove it, then that means you're designated as a habitual. The law changed back in the day. Didn't matter how many times you had been to prison, you wouldn't be designated as a habitual. But all around the country, they started doing this 3 strikes and you're out thing, right? So with you, instead of your range of punishment being...
Here's the reality check. Judge Boyd calmly explains how drug cases actually work, especially habitual offender laws. This is not TV law. Prior convictions change everything, including how much mercy is even legally possible.
For a bench trial, and what I can tell you, I've had bench trials before me where I found people guilty and I found people not guilty. If you come before me and you're found guilty on a bench trial, I can't give you probation. Your minimum is 25. And I know sometimes people are like, oh, it's just a drug case. I can't believe I'm getting 25. But that would be your range of punishment. It's completely up to you. So for your case, we'll set it for a jury trial.
Like I was going to say, it says here that I was found with, 1 gram. I had 3.2 grams.
Oh, no. So here's the thing.
Shut up! Shut up! Shut up!
And there it is. The judge shuts him down for a reason. Anything he admits here can come back to haunt him later. Talking too much in court is one of the fastest ways to hurt your own case.
They're putting you at a 3rd-degree felony because according to what I'm reading on the docket, it may be wrong. That's why I'm asking her to pull the indictment. You were in a drug-free zone.
That was on the sidewalk.
Yeah, here's the thing though, but drug-free zones, like schools are usually drug-free zones.
Yeah.
So if you're within a certain feet from a school, so that means that maybe if you have a possession less than a gram, it's no longer a possession less than a gram. They enhance it because you're in a drug-free zone. And when they enhance it, it becomes a 3rd degree, you become a habitual. Your minimum is 25. Now, if it's just a regular state jail felony drug case, then you're most likely looking at 2 to 20 years unless there's something else out there. So that's where we are.
So 44B doesn't work on this one either, right?
They're not, no.
Nothing like
No.
that. 44, nothing like that. Okay. Well, when they arrested me that day, it was San Antonio Independent School District Police. They called.
They're allowed to do that.
Called that San Antonio Police Department twice, and they never showed up. So they took me to their facilities, and they took my wallet from me. They took my credit card. They took my money, and they put it inside my backpack, and they kept it in their facility. And to this
You don't have it?
To this day, I'm unable to retrieve my money, unable to retrieve my credit card because.
Okay, let me explain something to you, and I want you to internalize what I'm saying.
And I thought it was a violation of the 14th Amendment.
All right, I want you to internalize what I'm saying, right?
Yes.
I've had clients in the past before who have told me, like they get arrested for something. Let's say they get arrested for a drug case, right? And my client will tell me, hey, Stephanie, the officer roughed me up. My case should be dismissed. They think it means it's a wash. And I tell them, the fact that an officer maybe roughed you up, that is a whole different case. We're just here dealing with the criminal case. So the fact that you're saying that the school division, they kept your license, they kept your credit card, maybe they took some money, that's a civil matter. It has absolutely usually nothing to do with the criminal case.
This part matters more than most people realize. The judge explains the difference between a criminal case and a civil issue. Even if police mishandled property, that does not erase drug charges. Two separate legal.
That you've been designated by the state, they're saying you're a habitual offender. If you go to jury trial and are found guilty, you're looking at a minimum of 25.
Okay, have you guys PD trial?
I'm sorry?
PD trial?
Oh, sure. We'll get you your trial.
Judge, and for the record, the offer that I conveyed to my client was,
Oh, I don't need to know the offer. If you want to put the offer on the record, you can.
yes,
All right, just go ahead and go over there.
A few moments later.
And you're Mr. Hernandez?
Yes, ma'am.
All right, you've had a chance to have everything explained to you?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the habitual offender enhancement allegation.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
You're charged with possession of a controlled substance penalty group 1, less than 1 gram in a drug-free zone. The range of punishment is anywhere from 2 to 10 years.
Yes, Your Honor.
According to the plea, the state is proceeding on count 1, waiving the enhancement. They're asking that your punishment be assessed at 2 years in the prison. There's a $1,000 fine, and there are no applications. Is that correct?
Yes, Your Honor.
Any objection to the court changing the plea bargain paperwork to reflect that there are no applications?
No, Judge.
No, Judge.
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just follow the plea agreement, Judge, and sentence my client to the agreed 2 years.
2.
2 years.
Yes. All right. The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $1,000 fine, time and money to run concurrently. I'm going to request a therapeutic community for you. It's to help you with any type of drug addictions you may have. I do not have the authority to force them to place you in the program, but they'll see in the judgment that I'm requesting it for you, and you'll still need to request it. Do you understand?
Yes, correct, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. We can go off the record. Here's the thing. If you don't take care of this drug addiction you have, what's going to end up happening is you're going to end up in and out of prison. And if you have another charge, this may not be your attorney, I may not be the judge, this may not be the prosecutors. And your minimum sentence, depending on the type of felony it is, your minimum is 20.
This final warning hits hard. Judge Boyd isn't just sentencing, she's forecasting the future. Addiction plus repeat offenses equals decades behind bars. The question now is simple: does this wake him up, or is this just another stop on the way back to prison?